Avelino Lopez.
Good job.
Hello. Yes, please. Thank you. All right, so this is a discovery acknowledgement. So the defense is saying that they received all the discovery that the state currently has in their possession. If something else comes up, the state is supposed to legally let the defense know, and then the defense may need more time to prepare. All right. So was an offer tendered in this case?
It was, Judge, but that discovery agreement, she just gave me this, the last video of actually the crime itself, supposedly.
All
So
right.
I want to spend a little time going over it with him. I don't need a very long reset on this.
All right, so how long do you want the plea deadline date out?
Weeks.
All right,
I don't-
Ms. Ferguson, can I have a 2-week reset on Avelino for a plea deadline date? Is that good for you? All right, so we're going to be back on October 7th. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date is going to be a jury trial setting. You understand?
And just to let the court know that that plea that they offered is, State and I both talked about it because she's going to review those videos too. That plea is subject to change.
Okay. All right, thank you.
Thank you, Judge.
Hello.
Morning, Judge.
Hi. What's happening with this case?
I am tendering a dismissal.
Okay. And if I could see the dismissal, please. All right. So on this case, when the state tenders a dismissal, they have to put a reason for the dismissal. Sometimes the dismissal can be they pled in another case, so we're taking this in consideration. Sometimes they're dismissing because they need more information and don't have enough, so they dismiss it and say further investigation. Normally, when they dismiss for further investigation, normally it doesn't come back up again. So in this case, they're filing a motion to dismiss because they're saying there's insufficient evidence. So I'm going to sign it. And so it's not my job to say, well, what do you mean it's insufficient evidence? How is it insufficient? So if it appears that it's in order, I normally sign it. Unless the defense says we object, we don't want you signing the dismissal. Which
Does that happen?
Oh, that has happened before. It usually happens if the state say we're dismissing, but we're going to refile it. And there's a law that says that the court does not have to sign a dismissal. So if the state objects and says we don't want the dismissal.
Quick legal note: whenever new evidence pops up, the state must hand it over to the defense. Fair fight rules apply. No surprises allowed in court.
We still want a trial, then you can go forward with that. Thank you for dressing appropriately for court. They dismiss your case. They say there's insufficient evidence. That's where we are. All right. Good luck to you.
Thank you.
You're welcome.
Any decision?
Yes. Thank you.
Thank you, Judge.
So that was set for jury trial. So it's Jesus Salazar. And we'll see what's happening because he didn't answer docket. Who's here on Jesus Salazar?
Yes, Your Honor, I'm here for him. Contact with him, Your Honor.
No contact?
No, ma'am.
Well, it shows already that he has an active warrant. So once he's picked up, we will make sure he's on the docket.
Thank you very much, Your Honor.
All right, thank you. Yes.
Your Honor.
Well, sometimes when people are arrested, one or two things can happen. One, an officer can talk to you and not arrest you at the scene. And then the next thing you know, you have... No, it says in the system.
No, Judge. Ms. one. It's not for the.
No, that's what it says. It says fugitive on the case that I pull up. Okay, why doesn't it say it's precinct in here? So issue a judge's warrant. So anyway, what ends up happening is normally people, if you'll come around, let me show you something. So when it says on the system, W and That's explanation point. That's a warrant, but it doesn't tell me what type of warrant. So other people have on their system, they can see if it's a, for tickets or if it's of something else. I can't see that. So anyway, he now has a judge's warrant. So what that means is they will not, a magistrate judge who has him come through, when they see a judge's warrant from the 187th, they're not going to give him a bond. They're going to make it come back here. And sometimes you have to do that because other judges won't know, hey, this is the third time this person hasn't shown up for court or something of that nature. So this is Odyssey. So they're working out the kinks. So sometimes people will get arrested at the scene. Sometimes they don't. If they don't get arrested at the scene, what will end up happening at some point in time, a warrant is going to be issued for that. And you could be out just driving around. Maybe you pick up a traffic ticket and you have this warrant.
Boom, case dismissed for insufficient evidence. But remember, dismissal isn't the same as innocence. It just means the state couldn't prove guilt beyond a reasonable doubt.
You don't know about. All right, Szymanski and Corbin. Szymanski, you need to start. All right, so where are we on discovery?
I think we're good, Judge.
All right, so I'll need a discovery acknowledgement signed.
You got it.
And has an offer been tendered?
Just this morning.
Mr. Szymanski, if you could unmute, please. All right, how old are you?
I am 22.
22. All right, Ms. Ferguson, recall this in 30 days for a plea deadline date. I'm giving you extra time because sometimes when people are younger, they need to internalize all the consequences.
He's got to talk to his parents too, Judge.
Okay.
They're very involved in his life. So
All right. All right, so on October 23rd, you're going to need to appear in court, okay?
Okay.
And that will be at 9 o'clock. Is there anything else, counsel?
No, Judge.
All right, once you sign the acknowledgement of discovery, you're excused. And Mr. Szymanski, you're excused.
Okay.
All right, and jury trial, correct?
Yes, Judge.
All right, so I'm going to have you all back here at 1:30.
Thank you, Judge.
You're welcome. And is he dressed? All right, so if you could. He's not dressed? All right, counsel. They're telling me, and can I see the state on Perez?
Yes, Judge.
All right, so they're telling me your client is not dressed for trial. And they're saying that this was set for a discovery hearing, not for jury trial.
That's correct.
All right, so because you filed the election for punishment, I'm thinking,
I just want to get ahead of everything.
all right, so is he out here?
Yes, he is.
All right, Mr. Perez, if you'll come up, please. I saw the shock on the state's face. They're like, what?
I was like, well, I thought this was our first or second setting.
Yeah.
Sounded pretty good to me.
Hello, Mr. Perez.
Hey, Dan.
Oh, I'm doing okay. So anyway, you're actually scheduled for discovery today. That's why you're not dressed. Okay. What happened to your face?
Long story.
All right. Is there anything that you need help with
No.
at the jail? Everything's okay?
Yes, ma'am.
Okay.
Here's a scary reality check. You could be pulled over for something tiny, like a broken taillight, and suddenly find out there's a warrant with your name on it. Nightmare fuel, right?
All right. So they're requesting a jury trial. State, did you tender an offer?
Yes, Judge.
All right. And you want a jury trial?
Yes.
All right. If you all confer with Ms. Ferguson on the earliest jury trial date, you can do a jury trial date or a bench trial if the state agrees to a bench trial, because the state is entitled to a jury trial as well. What I can tell you is if I'm hearing the evidence, that's what a bench trial is. I will make a decision. And if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't, I'm going to find you not guilty. And I tell you this because I can give you a bench trial very quickly, but with the jury trial, there are going to be some issues. So if state and defense, if you confer with Ms. Ferguson.
Perfect. Thank you.
Thank you. And normally it should be very quick. It's a theft case, so probably 2 days. And if we can do it before the new year, that would be preferable. Well, just put it on one of the dates with one of the murder cases. Hi, because the murder case may end up working out. So put it as early as possible. October when? All right, state, it's going to be October 14th. And counsel, there are other cases that are ahead of you. Yes.
An issue that one in 14 January. I haven't had something already out there. Some people in my side that failed to appear to we're coming at in after warranty.
So are they going to, do you anticipate going to trial in Atascosa on that case?
I don't know. My guy just, court. No.
Right, because what I'm saying is we could probably put him for the October, Norman, we could probably put him for the October 15th date.
October 15th?
Yes. And then if we're not currently in jury trial, then we would do jury selection in the morning and start testimony in the afternoon. Yes.
Okay.
All right, Miss Ferguson, we'll put it on the 15th. State, it's going to be October 15th. And if we're not already in trial, we'll do jury selection in the morning and testimony starting in the afternoon. All right, Sariana. All right, so I know that you were recently placed on both of these cases that he has. So where are we with discovery?
Well, September the 4th, I tried to get discovery and all I got was an affidavit for arrest, which
Okay.
gave me some background. There's more there. I'll talk to Ms. Yates. A lot of this I've got to go to.
Just one second. I'm going to wait to this side because they're talking very loud up here. We'll wait till they're done. All right, yes,
I've got to go to Ms. Yates' office and see some of the discovery.
okay,
And also, they're not prepared to give an offer just yet.
okay.
So if we could have a reset for me to do my discovery.
This is Courtroom Strategy 101, Bench Trial versus Jury Trial. One judge decides quickly, risky but fast. A jury trial? Slower, emotional, and 12 strangers hold your fate.
Is 30 days enough for you to do your discovery?
For me, it would be. Would that be?
That's fine with me. All right, I need a 30-day reset for discovery. October 23rd.
That'll work.
All right, so we're going to come back on October 23rd because of your case. There's certain things that the attorney can only see, in person with the prosecutor, okay?
Thank you.
You're welcome. Is there anything else?
That's all good.
Nothing from the city.
All right, thank you.
Thank you, Judge.
You're welcome. David Lopez.
Your Honor.
Yes. Hello, how are you doing?
Good morning, Your Honor.
Good morning. All right, so again, the state has tentative dismissal on this case. And on this case, they're saying there's insufficient evidence. So it's not my job to say, how's your evidence insufficient? I just review it. And if it appears in order, if the defense has no objections, then I sign it. Do you have any objections? Yeah.
I thought he was going to object.
And I always tell people, I remember I was a brand new attorney and I was sitting in court and the state tendered a dismissal and it was in Judge Sharon McCrae's court. And so I'm sitting there because that's how you learn. You just go to different courts and you sit. And so the state tendered a dismissal and the defense attorney stands up and says, Your Honor, we objected to that. And everybody was like, what's going on? But I understood after I talked to him why he was objecting to the dismissal, because it was one of those for further investigation and we're going to refile. I don't think they were ready for trial. That's what it turned down to. And you know what the judge said? I'm not signing it. So
We picked a DWI trial and the state picked the jury and then dismissed and didn't give us a chance. And we objected to the dismissal and the judge continued, swore him in, and then allowed the dismissal.
yeah, so that's the other thing. And so the reason why he did that, if a case is dismissed, even if you've done jury selection and the jury has been sworn in, then double jeopardy doesn't attach. So that means that the state could come back and refile. So.
Your Honor, thank you very much for all your consideration in this case. We'll be excused.
Yes, and thank you. You always dress appropriately for court, outshining the defense attorney and all. Well, yeah.
Well,
All right, Lamar Simmons.
That's right.
Yes. Did he step outside?
One moment, Your Honor.
All right. So today is their final plea deadline date. So they're going to let me know whether or not they've reached an agreement with the state or whether or not they're requesting a jury trial. And I've discovered giving plea deadline dates help attorneys. It helps their client, helps the state, because you know, this is it. This is the final time.
Notice how firm the judge is here. Deadlines are leverage. Either take the deal or roll the dice at trial. No endless stalling allowed.
Hello.
How you doing?
Oh, I'm doing okay. How are you doing?
Not so good.
Oh,
Judge,
well, I'm sorry to hear about that.
Is that right?
All right. So,
we've been here a few times to propose a counter offer.
Mhm.
We were partially successful in proposing it. Without going into the details of the offer, Mr. Simmons can't accept it currently. He's asked for some additional time. He's from another state, so he has some questions about Texas law and how this applies to him. And I've discussed this with him in prior studies, but he wants a more informative, thorough, more detailed discussion.
all right. So what I can tell you, Mr. Simmons, is that an offer was tendered to you July 29th. And so you came back on August 28th. So that was more than a month. Well, not exactly. I say a day shy of a month, maybe. And then I reset it again for the 23rd, which is today. So today is the day. Either you've worked out an agreement with the state or you have not. If you have not worked out an agreement, then this is being set for jury trial. And the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court.
Can I speak now?
Yes.
What I'm saying is, well, my understanding of this was when I first gave me an offer, it was just thrown at me. But then the next offer, it wasn't off. Offer today was something that I wasn't heard of to today.
Mm-hmm.
The last two offers was jail time.
No. Here's the thing.
Offer today was something that I wasn't heard of to today.
Mm-hmm.
The last two offers was jail time.
No. Here's the thing. I'm not allowed to hear what the offers were. This is what I can tell you. Sometimes offers will change because maybe the defense attorney may talk to the state. And then the state may see things a different way and they may say, that first offer that I made really wasn't just. Defense has come to me and told me reasons why the offer should be something else. And then maybe they will agree with the defense attorney and offer that. So sometimes offers do change. Sometimes people will say, you know what? I'm going to take this to trial. And then maybe at trial, maybe the state doesn't have their witnesses, or maybe the offers change because they've had a chance to talk to the witnesses again. You just never know.
What do you think, viewers? Should defendants get more time to consider offers, or do strict deadlines keep the system fair? Drop your thoughts below.
What I'm telling you is today is your plea deadline date, and you've had over 60 days to think about whether or not you want a jury trial or not. So, counsel, are you available this afternoon?
Excluding the 1:30, the 175th doesn't have docket till 1:30. I'm set there for two people, but I'll be here this afternoon.
All right. So, well, I tell you what, you have till 11 o'clock to let the court know. Is that good for you, counsel?
Perhaps afternoon would be best.
All right. So, how long is it going to take you in the other court in the afternoon?
That I'm not certain, but I would hope to be here hopefully prior to 2:30.
All right. So you're going to need to be back here at 2 p.m. And you need to let the court know whether or not you've reached an agreement with the state. If you have not, then it's going to jury trial.
How could I negotiate about a cop out to something that I'm just hearing for the first time? Every time when I come to court, outside of court, I'm supposed to have contact with my public defenders discussing this case.
All right. So
I'm just hearing it every time I come to court. That's when I talk to my public defender.
All right.
Your Honor,
It was like kind of shock or surprise to me. That's what I'm saying.
the offer that was made July 29th I had explained to him that I was proposing a counter, that I explained what the counter was, what the counter would entail.
Mhm.
And I was successful in proposing that, except there's in the provision of the penal code that would authorize you to do something, there's not a number we could agree with. So we did make a offer that I explained to him. Unfortunately, it's just not an offer he could accept.
Okay. All right. So,
But I will speak with him after court right now.
okay.
And around at 2:00 we'll be back here.
All right. 2 p.m. Thank you.